for this newsletter, and I am very excited to be joined by Lisa Graves, who is, she's got a lot of titles. I was putting together this introduction, this little document, and I could go on for a while. She's a lot of distinctions. She's the co-founder of Court Accountability and True North Research. She's the former chief counsel of the Senate Judiciary Committee. She wrote a book you see in the background, Without Precedent. It's about John Roberts' takeover, moving the Supreme Court to the right. And she co-hosts Legal AF on Midas Touch Network. So she's very busy. So I'm very lucky that she's joining me here talking about the Supreme Court. So Lisa, thanks. Without further ado, thanks for being here.
Thank you so much for inviting me. I was chief counsel for nominations. There was a chief counsel above me, but, so I don't promote myself. But thank you so much for that kind introduction.
It's very humble of you. I would. That's like a while ago. So, there you go. That's the kind of person you are. So, thank you for being here. And I guess we can jump right to it. There's actually news that came out. I follow voting rights a lot. I'm not a lawyer, but a journalist. I cover that a lot. And one thing I've been covering a lot is the executive orders on mail-in voting. Obviously, this week the Supreme Court ruled that they can, ballots can show up a little bit later as long as they're postal stamped, postmarked by election day. But just today, a judge court blocked the USPS's plan to withhold mail ballots from states that wouldn't cooperate and hand over just their unredacted voter rolls to the administration. And that was a big part of his executive order. And I'm curious what you make of that, because, it's the Supreme Court session's done. They're going to hear some more voting cases in the fall. But what do you make of that? Does that mean that they're not going to be able to do it, or are they just going to, what do you think?
Well, that is a great result at the lower court level, because that order, that intention by Trump and by the Postmaster General Dennis Steiner is unconstitutional, is outrageous. But that's the lower court's determination, which is spot on the law. The U.S. Postal Service has no business playing a role in trying to implement Donald Trump's unconstitutional effort to take over and federalize the elections. But clearly they're signaling that they're going to continue to try to move this tack forward. And, this happens in the aftermath of the decision by the Supreme Court, as you mentioned, in the Watson case, where the Supreme Court, the Roberts Court, agreed that just because Congress set a day of election, a uniform day of election for congressional elections, it didn't mean that you couldn't have early voting or, when the votes could be counted. And, the claims in that case were just ridiculous because, on election day, on the national election day in November, what we see in the media is the projection from the polls. And so it's not the actual result. In many counties, particularly in cities where there are millions of voters, it takes a while to count the votes and then to allow people to fix their ballots if they made a provisional ballot, like they came in and didn't have an ID in that ID state, come back in, give their ID, so their provisional ballot will be counted. And in that Watson case, what was at issue was ballots that were postmarked by election day, and then arrived afterwards. And we, of course, have no control over how long it takes to get the mail. In fact, under Donald Trump's postmaster generals and under his sort of takeover of the Postal Service in years past, what we saw was the consolidation of mail centers, so that everyone's mail is taking longer because basically Louis DeJoy was trying to part out the Postal Service by creating these regional processing centers. So your mail isn't postmarked at your post office unless you walk in the door and get it postmarked. It gets sent off someplace else and then sent back. And so it's a common sense rule to say that the postmark is the right date, and it just takes a couple days. And by the way, you may remember this, back in 2020, Donald Trump went to court to prevent the state of Pennsylvania counties from counting the ballots ahead of the end of election day, because they knew they were going to have so many mail-in ballots due to COVID that they were going to have to count those ballots into the night, into the next day, and the day after. And back then, Trump didn't want those ballots open until 8 or 9 p.m. on election night. And that meant that there were going to be even more delays in finalizing the results of the election. So this is just the same old game by Donald Trump trying to claim any election he wins is legitimate, any election he or his loyalists lose is illegitimate, and trying to use the postal service to accomplish that and disrupt our elections.
Yeah, and with the California election recently, right, with the primary election, I mean, that's the one he criticized a lot because they were counting afterwards, right? Because they
Yeah.
were counting for days because California is such a mail-in vote state, but he, like you said, in Pennsylvania in 2020, he wanted to stop them from counting afterwards, and so it's like he's setting it up so that he can just so he can like delegitimize all of it, right? He's
Yeah.
creating these obstacles so he can say, oh, look, it doesn't count.
Yeah, I mean, and in Pennsylvania, it was like they couldn't open them that day during, or ahead of election day. They could only open them after the polls closed. And of course, this all happens in the midst of Donald Trump himself voting by mail and say, of course he did, of course he can. And in some states, people only vote by mail, and in other states, people predominantly vote by mail because it's more convenient. In California, that was a particularly unusual circumstance compared to other states because California has this super restrictive matching of the signatures between the signature on the poll, the rolls for the voters, and the signature on the envelope. And I don't know about you, my signature is often different depending on how long I'm taking to sign it. But that's what was taking so long in California was first the numerosity, like millions of ballots in Los Angeles, but also then comparing, one by one those ballots. So this is just another tactic by Trump. And what I'm also concerned about is some of the reporting out this week about the notion that Trump has assigned a sort of right wing journalist might be the wrong terminology for a guy who's buddies with Steve Bannon, but he's assigned this guy who was a journalist to mount this case of supposed foreign interference
Right,
by pushing for the declassification of documents from the intelligence community, which we think, or I think, is another way for Donald Trump to try to assert by executive order that he can nationalize or federalize the elections if he claims there's foreign interference when we all know what happened in 2016, which was Donald Trump invited the foreign interference of Russia, saying, "Hey, go get those emails of Hillary Clinton," and then denied that there was any, actual Russian interference, even though the intelligence community found that Russia was buying, Russian bots in essence, and groups were buying huge numbers of ads in Facebook to divide Americans. But leaving all that aside, that's where the foreign interference was. It was Donald Trump inviting the foreign interference back
right,
then. But, so we this election continues to be at risk. It continues to be at risk from the machinations of Donald Trump to try to use the Postal Service to block the Postal Service from giving ballots to Americans who are entitled to them, but their state doesn't cooperate with Donald Trump's demands for their voter rolls. And by the way, on that issue, Donald Trump has lost over and over and over again on those demands. And Mark Elias and other groups have spearheaded that litigation, and that's because Donald Trump has no right to the voter rolls of Americans. And in fact,
right.
the fact that our voting processes is so decentralized is one of the things that helps guard against election theft, the guard against someone internally or externally manipulating voter rolls on that kind of scale.
Yeah, I mean, and you bring that up being blocked over and over to try to get these voter rolls. I mean, it was something that Accord, I think, blocked a week or two ago, right?
Yep.
This national list, and I did a story about this. Like, I work with the union, and we did a long story about it. I was getting confused by the amount of lists and like the things they were going to check it against. It
Yeah.
was pretty confusing. Like, that was my job to know. Like the things they wanted to check, people's, I guess, names against the what you call the save system in terms of the Social Security. Then they wanted to get the what you call the the post office like a list that people can check it against. It just seems all an effort to purge voters. And now I understand that they're still working to try and the Supreme Court's going to take a case about voter purges in the fall. That's going to make it possible to purge things even closer to an election.
I mean, it's really extraordinary. One of the things that was astonishing when the Watson decision came out was this absurd claim by Trump's allies saying that they were disappointed because they really are concerned about voters and voters' intent. If they were concerned about voters' intent, they would be trying to make sure the voters' ballots are counted, not
Right.
trying to find everything everywhere under the sun to disqualify them. And we've seen part of this playbook before. This was the Chris Kobach playbook out of California. around and over the past couple of years that there's like 30 Lisa Graveses. One of them is like into witchcraft. I don't know who she is.
Cool.
She, writes books about it. She's not me. I don't know how many people share your name, how many times you can't
Probably not a lot,
name
but
on Gmail, right? Of like Lisa Graves at Gmail, like that's taken
yeah,
over and over. Like there are common names. And so, we can't have a 1-800 Big Brother situation where someone in Washington who's loyal to Donald Trump is deciding whether you can vote in whatever state you are because they think there's another person with your name in another state and supposedly that's you. It's ridiculous. And these methods have not been proven to be accurate at all. In fact, one of the reasons why the resistance to the SAVE Act in Congress is so strong, largely by Democrats, but by some Republicans, is because this again is a solution. It's not even a solution, but it's claimed to be a solution in search of a problem that doesn't exist, which is
right,
voter fraud. There's no cognizable voter fraud, no statistically significant voter fraud. People who vote twice, if they do, it's super rare. They risk jailing. If they're an immigrant, that's even rarer for an immigrant to vote. They risk deportation and, a criminal sentence. This is not a real actual threat. Every single blue ribbon commission that has looked at it has found this is not actually something that's happening in America. To the extent that there ever is some amount of voter fraud or people voting twice. In recent years, it's been a lot of Trumpsters, but like, by a lot, I mean like less than a dozen. You
right,
know, so
yeah,
it's not a real thing. But that SAVE Act, which Trump now is trying to use the Supreme Court decisions to push forward as well, is about disqualifying millions of voters from being able to vote, and in particular, women who take their spouse's name when they get married, or husbands who take a joint name when they get married, or same-sex couples who have a hybrid name. And if you don't have that, if your birth certificate and your driver's license don't match, they may disqualify you, particularly in, so-called red states that are, cooperating with Trump.
yep,
And this is outlandish because it doesn't just affect Democrats. I don't know why they think it would. It would affect people from both parties, all parties, but particularly would be a hardship for women. And this comes in the midst of, sort of close association or bosom buddies, for example, by Pete Hegseth with some preacher who claims women shouldn't even have the right to vote.
right,
Like that's also absurd. Of course, the Constitution says women can vote, and of course, women should be able to vote. But
right,
this is not happening in a vacuum. This is a wholesale effort to make it harder for people to vote. And the other part of that SAVE Act is access to these voter rolls. It's what they
yes,
want to gather, to glean in order to stop votes from counting, to basically make sure that only the votes they want will count. And that's just not how a democracy is supposed to work. So, I'm happy the court did not go along with the effort coming out of Mississippi by the Republican Party to block the votes from being counted if they are received after Election Day, within a few days of Election Day. That would affect voters from both parties. I think that's also one of the distinguishing components of what we're seeing. We're seeing out of the Supreme Court is that if the issue would very much help Republicans, like the changing of the maps, the voter the voter changes this spring, then the Republican appointed judges on the Supreme Court are very happy, full speed ahead, go ahead, redraw your maps. But something like counting those ballots that are mailed after the fact, in that instance, it doesn't give the Republicans a decided advantage, and so they
right,
didn't do it. On the other hand, when you look at the FEC case from just yesterday, where the Republican Senatorial Committee wanted to strike down the long-standing spending limits for coordinated activity, against Democrats who were opposing that largely. Of course, the
of
Republican-dominated
course,
Supreme Court said, "Sure, yeah, go ahead." In fact, the First Amendment compels you, in essence.
right.
The First Amendment blocks anyone from regulating, blocks Congress from limiting this activity, even though just 25 years ago, the Supreme Court said there's nothing unconstitutional about these types of spending limits.
I mean, that was going to be my next question. So perfect segue. Like this is a big deal. We talk about Citizens United as a huge, huge kind of groundbreaking, shifted the terrain in terms of elections. This one, like you mentioned, the being able to coordinate money between party and campaigns, probably I don't know if it's going to be as big, but it's huge. And I think it's probably gotten less coverage because of the birthright citizenship and other everything else, which I also want to talk to you about birthright citizenship. But could you walk us through what this means practically? And because I think it's gonna change, I'm sure, a lot this fall.
Yeah.
A, because Republicans have a lot of money, but B, just like the way everything works, what's allowed.
Yeah, this I think the coverage on this has been harder just because it's a complex part of the campaign finance law, otherwise known as the anti-corruption law. And most people know, like most people in America don't make enough money to even meet the limits. So, you wouldn't even know there was a limit because you couldn't possibly like give enough money to a political
Right.
party or to a candidate to get the limit based on the average per capita income in the United
You have to
States.
max it out at $10
Yeah,
donations.
it's sort of like, just by the way, back when I was working for the federal judiciary, when I was the deputy chief of the Article 3 Judges Division, and we were working with the judges in July, I noticed that their pay went up. And I asked my boss, like, why is this? And he says, oh, that's because of the cap on Social Security. So by July, all the federal judges in the country stopped paying into Social Security because they've hit the cap. I think it's now like 120 or something.
Yeah.
And then they get basically a take home pay increase. So you wouldn't know it unless you had that salary level. So it's the same thing with this campaign finance
Right.
rule. Ordinary Americans aren't ever going to run into that spending limit because they're not even running into the overall limit of donations within a cycle, which I think is somewhere around $128,000 or the equivalent, right? So, but
In a
what the
lifetime, they don't
reality,
spend that.
but the billionaires care, right? Because they
Sure.
are hit by it. So this is about helping the billionaires again. That's why I think the Citizens United decision shouldn't be called Citizens United, despite its actual technical name. It should be called Billionaires United because that's what it's really all about. So this is a way in which, if you look at the actual sort of numbers of billionaires, numbers of Democratic billionaires, numbers of Republican billionaires in the United States, there's more Republican billionaires. And those billionaires are very active in electoral politics. George Soros is someone who has been active in the nonprofit sector, in particular, in trying to protect civil society from rising authoritarianism. But when you look at the numbers of billionaires on the right and the left, they have an advantage, and so you can see how they would want to have no limits on this coordinated spending, and that's what this is about. And it is a further effort by this Roberts Court to limit the ability of Congress to regulate corruption, to limit the undue influence of these billionaires who I think the famous phrase, it might have been Bob Dylan, was, money doesn't talk, it screams. But in this instance, money allows these billionaires to scream so loudly and through
Mhm.
so many megaphones. And the coordination is a big deal because it allows them to have, a more coordinated campaign toward the victory that they're hoping for. I have to say, because I just feel like I'm compelled to say this, but so I hope you'll bear with me. But the
Yeah.
Citizens United decision was a fundamentally illegitimate decision, not just on the merits, not just on this arrogance of the Supreme Court claiming that the First Amendment commands that Congress cannot limit the spending of this outside money to influence our elections. Like that itself was an outrageous, grafting onto the First Amendment to protect big money, dark money. But it was also a decision that was 5-4. And Clarence Thomas sat on that case, even though we now know
Right.
his wife, Jenny Thomas, received $500,000 from Harlan Crow, the Nazi memorabilia collector, a real estate heir in
Yeah.
Texas. He gave her $500,000 to start a Tea Party group to take advantage of the decision to come. She got that money, or was told about that money, like around New Year's Eve, just 2 weeks before the decision was about to come out in Citizens United. She rushed with her friends to get an LLC so she could deposit the check, an expedited LLC. This was on New Year's Eve. There's
Oh,
no scenario in which Jenny Thomas doesn't talk to Clarence Thomas about the fact that their benefactor, who's been taking them on trips and
right.
luxury
All around the world.
vacations, just gave her a $500,000 for her org. And then just a couple weeks later, Clarence Thomas is there casting the fifth vote in what would have been a 4-4 decision, which would have let the campaign laws stand. And he cast the deciding vote. That decision never should have gone forward. And just to underscore the arrogance and outrageousness of this, in that case, in Citizens United, Clarence Thomas issued a concurring opinion claiming that disclosure would be unconstitutional because it would chill the giving of money. Oh, I'm sure.
Yeah.
I'm sure.
So then on his
But did
personal
he
interest in that.
admit that his wife had just received, a six-figure sum from his billionaire benefactor? No, and so that decision is poisoned from the jump.
Right.
Citizens United, and this decision builds on that Citizens United decision. We're going to have to get that decision overturned. We're going to have to restore the ability of Congress to, put in force common sense rules about this dark money, because these billionaires, it shouldn't be a dollarocracy. They shouldn't get so much more say than us in our elections based on these massive megaphones. And now, due to this case that you so kindly asked me to describe, now to do so on a more coordinated basis.
So like the party, let's say RSCC, Republican Senate Campaign Committee, they can work with, let's say, Harlan Crow, Elon Musk, whoever wants to donate money, whichever super PAC, whichever whomever, give money. They can give money to these committees, and they can just go spend it alongside with the candidates, right? It's like they can communicate, they coordinate. It's now everything's go for it.
Yeah, there was a cap on how much could be spent that could be coordinated. In order to It was the sort of the last little sliver of, so just to step back a second, the reason this activity is called dark money is because, back in the 1970s, when Congress replaced the Anti-Corruption Act with the Federal Election Campaign Act, FECA, what they were trying to say is you shouldn't be able to give more than X amount to any politician for his or her campaign and to the party. And you shouldn't be able to give more than, Y amount in a cycle. And so, and if you give money, it's disclosed, and who you are is disclosed. And the idea was that would limit the influence of any one person on a candidate. If everyone can only max out the same amount, let's say it's $2,800 or something, then everyone is sort of equal. That the millionaires, the pre-billionaires at the time, couldn't give 100,000, $1 million, and anything they gave to the party or to the candidate would be disclosed. And so, with Citizens United and the follow-on cases after Citizens United that created super PACs, what happened was suddenly there was the ability to give unlimited funds to a super PAC that you couldn't give directly to a candidate or to a party. And then there was the way in which these entities, these different nonprofit entities, were relating to each other. And one of the last remaining rules was this cap on the spending if coordinated money. So now that cap is struck. And so there aren't limits on how much money can be spent in that kind of coordination. So it really does supercharge the billionaires as if they needed to be supercharged even more.
As if they didn't have enough influence,
Yeah.
You wouldn't want to silence them. Elon Musk can't, he's always at risk of being silenced. That guy on
Yeah,
his
right. Well,
Twitter.
and you're right. Right. Some billionaires aren't doing dark money, right? It's right out in the open, but it's still too much money for any
Right.
one person to have, because then you have politicians that are beholden to that individual, and not to the American people, not to the people who voted for them. And that's because, what part of what Musk and others are doing is propagandizing individuals with disinformation, with, attack ads against the opponents in order to get their guy or their woman into office to do their bidding. And that's why so much of the congressional policy is distorted toward things like the so-called Big Beautiful Bill, which I call the Big Billionaire Bailout Bill, where our taxes, we're paying more in taxes than most billionaires. That's
Right.
ridiculous. It's not beautiful. It's big. It's big, but it sure as heck isn't beautiful. But
To
that,
get the bill.
we need to get that distortion out, not just because who can run for office, meaning, do you have a viable campaign if you don't have a billionaire on your side for some of these big races?
Right.
It affects what type of legislation is brought up, whether we're going to regulate AI, for example, or these data centers, or we're going to stop these massive mega mergers that are driving our not our cable bills but our streaming bills up and up and up. Are we going to regulate against poisons in our air and water? Or are we going to have a Congress that, is in the pocket of the fossil fuel industry? And so, this affects us in a lot of ways in terms of the quality of our life. And so this was another case, this case just this week by the Roberts Court, that basically puts billionaires in the driver's seat and leaves us behind on the road, on the side of the road.
And I feel like there's so many steps we have to take to get back to like even like equilibrium where we were even like 15 years ago, right? It's like and we'll talk about solutions in a second. But one thing I wanted to ask before we get there is the final ruling this week with birthright citizenship, and on the positive, they affirmed that as has been for 150 plus years, if you are born in the United States, you are an American, right?
Yeah.
In almost all cases. But it was like 6'3" / 5'4", right? Like it
Yeah.
wasn't. It was uncomfortable, and you know, it's crazy that it even got heard, right? Like the president could say no more citizenship for certain people. Like
Yeah.
that's Nazi-esque. It's insane that it got heard, but the fact that it's like 4 of the 9 justices, one away from a majority, said
Yeah.
that maybe the 14th Amendment doesn't say exactly what everyone's been saying it's been saying for 150 years. How do we get? And then you write this in your book how things have changed, but how do you even get to that point? And like, does that feed you? Like, are you obviously you're happy about the decision, but are you like looking at it like, oh, this is not over, we're in trouble however many years from now?
Yeah, I mean, this is a case where it reveals the utter lie of so-called originalism or textualism. They don't care about the text when it is against what they want. We saw that with the immunity decision where John Roberts invented immunity out of thin air for Donald Trump, basically pardoning him and then sweeping him back into power by signaling to some subset of the American people that he did no wrong and could do no wrong, that he could not be charged with the crimes that he, that there was ample evidence that he committed. And so in this instance, like you said, this shouldn't have even have been a case. This should have been smacked back, just no. This is contrary to the language of the Constitution. It's contrary to 140, almost 140 years of Supreme Court precedent. It's contrary to the statute, the immigration statute, and that's been on the books now for, I don't know, we're going on 80 years or more. This court is acting like every issue is just a brand new issue, and they just get to change their mind or disregard precedent, disregard history, disregard language to get to the result they want. It's utter lawlessness by the dissenting group. And for Clarence Thomas to basically assert that the 14th Amendment only applied to that first generation of newly freed slaves is it's so offensive and so grotesque. It really, really is. And then you have Kavanaugh sort of ducking and being like, "Well, I'm only gonna I'm only gonna look at the statute, not the Constitution." He keeps trying to have his cake and eat it too somehow because he doesn't have any principles, in my personal opinion.
Mm.
And then you have Alito and Gorsuch, who are united basically in advancing a really far right reactionary America. I'm not surprised given Alito's roots. You can see what he wrote when he was a Reagan administration attorney trying to get a promotion, how devoted he was to this right wing agenda, including, as I've written about, his opposition to having the apportionment cases, cases about protecting voting rights in America. That was something that was an anathema to him. And then, of course, Neil Gorsuch, who I can't refer to ever without really saying Neil, Fascism Forever Club Gorsuch. That's, kind of who he was as a young man, was, thinking that fascism was fabulous. He sort of claimed that, those were youthful indiscretions, I suppose, but his decisions tell a different story. The decisions
Sure.
tell a story that he is committed to this mega MAGA agenda, even when it is actually contemptuous of the Constitution. And remember, this executive order that Trump signed, he signed it just moments after he was sworn in as president of the United States, where he took an oath that John Roberts administered, that he was going to faithfully execute the Constitution, which, like I keep joking, although not so joking, execute, faithfully execute the laws of the United States, meaning to implement them, not kill them,
Right.
not kill
Right.
them, right? But there he is on January 20th saying, as of February 20th, he himself gets to decide who's a citizen, regardless of what the Constitution has always said. And this theory, this ridiculous fringe theory that they put forward about the meaning of the 14th Amendment, comes straight out of the playbook of the guy who was uh, advising Donald Trump to subvert the 2020 election, who got disbarred in California for
Right.
his efforts to try to prevent our votes from being counted in 2020. And that theory was put in place, or set out there in an op-ed to try to say that Kamala Harris couldn't run for president because she's not a real citizen because her parents were students, were here on student visas. That's the poisonous origin of this super nasty theory that we now have 3/4 of the Republican appointees saying, yes, what that means is that we're one heartbeat away from them
Yep.
possibly having the votes to do this. If one of the Democratic appointees were to not be on the bench with a Republican president and Republican Congress, they could get the votes to destroy our constitutional rights. In this instance, Roberts did the right thing, but he did the right thing in the aftermath of a whole 18-month period, basically, or 17-month period of doing the wrong thing. All these emergency orders, siding with Trump, overturning these lower court temporary restraining orders on all sorts of things. These massive cuts, the DOGE, the what I call the dodgy acts of Elon Musk to cut down agencies. John Roberts, sort of lifelong hostility to the Voting Rights Act, giving the pen to Alito to destroy what was left of the Voting Rights Act. This so-called administrative state attack through slaughter, where John Roberts eagerly overturns a precedent's been on the books for more than 90 years in order to
Executive.
accomplish his agenda to destroy what they call the administrative state, which is really the ability of us to have federal agencies that are implementing the congressional laws to protect our public health, to protect our economy, and to make sure that we have experts and people who, a bipartisan basis for resolving things. When you look at the FTC right now, what you see since last March is that uh, when Trump fired the Democratic appointees, that left two Republicans on that FTC. So there's not even a Democrat in the room. They don't want a Democrat in the room to be considering these mergers. They can't be in the room where it happens because they might see evidence or information about these mergers that would, become part of the public
Right.
record in a way that they don't like. They want to have just Trump loyalists making decisions. That type of cronyism is has not been part of modern American law, and for good reason. And John Roberts has swept it back in part because when he was some 20 something guy, and no offense to any 20 something year olds out there, he wrote a memo saying, why shouldn't presidents be able to fire these commissioners? And so here you have a guy who had this thought bubble when he was a young man and barely a lawyer. Only been a lawyer for a little while, but in a high position due to his, friends in high places.
Sure.
And then he, with absolute arrogance, uses the judicial power here in 2026 to impose his idea from way back when as a lawyer, when he was a lawyer for the Reagan administration.
Right.
That's not what a judge should do. A judge should be applying the law fairly. A judge should be honoring the precedents that court after court after court and president after president after president have honored, not just using Donald Trump as an opportunity to accomplish his personal wish list. And that's one of the reasons why I wrote Without Precedent, because John Roberts, wasn't put on the court to be fair. He was put on the court to impose this very regressive agenda for on the American people, to drag us back to before the New Deal, to drag us back to that robber baron era.
I'm curious, and you can't know what's in their hearts, obviously, but like you worked for a lot of years, kind of researching these people, knowing these people. You think about the birthright citizenship thing. Like you said, basically four justices didn't want to say, "Hey, the 14th Amendment just guarantees birthright citizenship." These guys are ideologues, hugely ideologues, but they also went to law school. They went to good law schools. They worked in the government for a very long time. Presumably they kind of understand the way people understood the Constitution for a long time. Do you think they're being opportunists, or really just they're finally taking the mask off and saying, "Hell, we never thought they'd allowed birthright citizenship"? I struggle because neither is good. They're either super cynical or insane. But it's hard to know which one is which.
Yeah, I think the mask has fallen. I think, when you saw when Ruth Bader Ginsburg died right before the 2020 election that September, and they had that big rose garden ceremony for Amy Coney Barrett, like the done deal. They were going to push her through as Americans were voting Donald Trump out of office, even though they had blocked Barack Obama's nominee for the Supreme Court in 2016, claiming you just can't have a confirmation during an election until the people vote. When they were pushing her through, that wasn't just about the anti-choice agenda, getting the vote it needed. It was about having 6 votes, which meant there was no single swing vote that could impede them from rapidly implementing their agenda. So, having have 5 to 4 means, one person could be swayed on an issue and slow them down. But once they got that supermajority, that sixth vote, then it's like, all steam ahead, right? The sort of approach that John Roberts had taken over the years, patiently, since he's a lifetime appointee under the current way the system is structured, just patiently. This year it's taking down the wall between the separation of church and state. This year it's gun issues. That year it's abortion. What another year it's they're setting a political agenda because they have hardly any actual required cases to take. Those are cases between two states. Almost
Mhm.
every case they take is a matter of discretion, meaning they have at least 4 votes who want to take a case. And so they're setting up this slate, and they set this up with this president in this year to take him up on the invitation to overturn Humphrey's executive, which has been on John Roberts' wish list for 40 plus years. And so I think that I think I think that originalism was always a made up theory to try to drag us back to some past era, to have us, enchained in their view of what a slaveholder would have thought should be the scope of our rights circa 1791. So it's been a tool, it's been an invented tool of regressivism. And I will tell you, having studied this deeply for many years, the origin story, in essence, of originalism was that they hated Brown versus Board of Education,
Right.
and they wanted to have a way to attack it. And there were these books that they were writing saying, "Hey, you can't have Brown versus Board because there were segregated schools in the District of Columbia after the Civil War, and so Brown versus Board was illegitimate in this originalist view." That wasn't gaining a lot of traction because even though there was, a continuing thread of white supremacy in the United States, there was not an appetite to embrace that as a legal matter, to say that
Mm.
Brown was wrong. And so they really decided to focus in on Roe versus Wade and attacking that their cause. And that's actually what the first meeting of the Federalist Society was all about. It was about Roe, and it was about this originalist attack on Roe.
Sure.
But now we can see that it doesn't mean anything, because if they were originalist, they would not have invented immunity for Donald Trump. It's totally
Sure.
contrary to the origins of our, the actual Federalist Papers, and
Yeah, they certainly weren't
Alexander.
trying to have a king then.
Yeah, we're not a king. We had,
Yeah.
we had created a revolution against king-like powers, and you wouldn't see them doing things like with the Voting Rights Act. The language is very clear in the VRA. The Mobile versus Bolden case that Congress was overturning, that was the case that Bill Rehnquist signed on to, who was John Roberts' mentor. Then Bill Rehnquist makes a call to the Justice Department when Reagan comes in and says, "Hey, hire John Roberts." And so he gets hired at the top of the Justice Department. What's he put in charge of? Oh, voting rights. The
Right.
attack
He's
on Congress's effort to fix this particular issue of vote dilution. And John Roberts spends hundreds of hours fighting it and loses. So
right.
he knows damn well that when he joined this opinion in the Calais case this year, he was accomplishing through judicial fiat what he could not win in the Reagan administration, which was to basically reverse the clock and allow these racially gerrymandered districts to happen by claiming they're not racial. If
That
they're
racial
flipped.
intent. That's what he did when he's in the Justice Department. He wanted that they had to prove that there was racist intent without a shadow of a doubt. Now I think Samuel Alito decided that racism doesn't exist in his world,
Yeah.
because
Well,
so this is something they've been trying to do for like 40 plus years.
yeah, and and to your point, like, I don't know what's in their heart, like, but I know what the effect is, and the effect is
Right. Yeah, they're very good at that. Now, one thing I wanted to, you were very involved in the kind of investigations into these, like you mentioned them before, Harlan Crow, all the corruption, all the amount of money going to, just it was loans or houses and whatever, vacations on yachts, things going to Alito, things going to Clarence Thomas, them first and foremost, others as well. I was very, I mean, I think anyone was like outraged by it, right? Finding out what they found out. More, I think, outraged by the lack of doing anything about it. Right, there was a point where Democrats had control, and when you're a judge or you're a Supreme Court justice, you have until like you can pass term limits, you have lifetime appointments. So I guess in some ways you already have immunity or impunity. But do you think that the lack of investigation into that and the way that was just allowed to just be and exist kind of like galvanized it in a way to kind of do whatever they want this term? Do you think if there was any sort of like real, I don't know, like public shaming or some sort of consequence that things would be different? And maybe that's just me projecting, but I've always kind of thought that.
Well, I really appreciate the point because this is corruption. It's corruption for someone to befriend a justice or a judge after they get on the bench. Then they're friends. Then there's some sort of massive loophole in Clarence Thomas's head where he's like, well, he was my friend, and so I'm just getting massive gifts from my friend. Doesn't matter. Even that his friend is actually a major donor to the Republican Party, to George W. Bush, to Republican causes,
Right.
helps fund these right-wing groups that
Friends just pay
are
each other's mortgages off all the time.
yeah, right. And or Alito, the arrogance of that absurd interview in the Wall Street Journal where he's like, "Hey, Paul Singer was just going to the same place as me, and he had an empty seat on his plane, and so it's a-okay." And I
Go
didn't
to
have
Alaska.
to
It
prove
was
it.
fine.
They were going on a vacation together. They were like, it wasn't like
Yeah.
a
We were both
surprise.
going to Alaska.
Yeah, who knew? Like you could just hang out at the private jet lounge and just catch a ride with a billionaire going your way. I mean, it is really blatant. It's really pretty outrageous, and the Paul Singer thing continues to be salient in part because Singer has major investments and had a case that came up to the Supreme Court, and there are cases coming up on fossil fuels where he's a major investor in fossil fuels. So there's a lot of overlap in terms of the billionaires who are either befriending these justices or who are backing campaigns to get them on the court. And I do think I take your point that it's possible that they've been emboldened in some ways by the lack of consequence. And in fact, you've seen Alito assert that there can be no consequences.
Right.
That under their absurd construction of separation of powers, there's no ability of Congress to regulate them, notwithstanding the fact that Congress created the size of the court or the Judiciary Act, funds the building, funds the clerks, created the legislation to have the judicial conference, which sets policy. Notwithstanding the fact that these justices every year sign a document that's required by the government, the Ethics in Government Act, saying that here's all the money that they have to disclose under federal law. But instead, you have this court treating itself like it is untouchable. And John Roberts has asserted as much in that so-called ethics code that he announced on the eve of the vote to issue subpoenas to Harlan Crow and Leonard Leo by the Senate Judiciary Committee. Suddenly, Roberts, releases this ethics code. Well, that ethics code has a lower standard than the code that applies to all other federal judges in the country,
Right.
first of all. Second of all, it's totally non-enforceable. There's no enforcement mechanism. Third, each of those justices, including Clarence Thomas and Sam Alito, signed that they comply with it, which means it means nothing, given all the gifts that they've taken, and in particular Thomas especially. And in that code, it absurdly, insanely says that these justices can sit on cases even if they have a conflict of interest due to the rule of necessity if their vote is needed to resolve it. That's not federal law. You don't get to sit on a case because someone wants the case to be decided in one side's favor or another by a biased person who has an interest in the case. No, the case then just isn't decided. It's a tie. Too bad. That's just the way impartial justice is supposed to work. So, yeah, I think they've been emboldened by the lack of consequences. But what I see is a real call for accountability, both among policymakers, and increasing number of policymakers calling for, court reforms of an array of types of court reforms, and people across the country saying this is rank, this is foul. We don't trust this court. This court is not worthy of our trust based on both the cloud of corruption that surrounds it, and also these ridiculous decisions that are contrary to the Constitution, statutes, regulations, contracts, precedents, and our, culture in a way, in terms of this, what this administration is trying to do, for example, and how this court has helped it. So, yeah, I think they've been emboldened, but I think there is a movement building for real accountability. And I would say when you think about the voting rights cases that you've written about, and have worked on so much, part of it is, in my view, about helping the Republicans keep control of the House,
Sure.
which Trump wants desperately to insulate himself from any accountability or any ability having to negotiate about anything. But it also protects the court from oversight hearings, from investigations into the corruption. So it's very self-serving of this Roberts Court to put its thumb on the scale to help Mississippi and Louisiana or Alabama, Alabama and Louisiana in particular, to change their maps midstream in order to try to give Republicans an edge. And then say, okay, but but not Virginia. We're going to leave that one to stand
Right.
down below, And so, they can do math. Those justices
Yeah.
can do math. And I think those decisions are not just about advancing the party that appointed them, but protecting themselves.
I wonder, let's say, it's actually something I've been thinking about. There was an effort, they made an attempt, the filibuster stopped it, to pass a new Voting Rights Act during the Biden administration in the first few years. If they were to do that today, or, with a Democratic president and Democratic Congress and legislature and Senate, would it be just struck down by the Supreme Court? Like, there's bigger reforms required? Is it so that, like, they need to, whether expansion or just, term limits or something, to get these guys off, or to dilute them so that they can't even just, because I mean, they'll knock down Joe Biden student debt relief, which is
Yeah.
like almost nothing compared to everything that they've allowed. But do you think that just like we're past the point of even passing laws it just needs to be new laws for the Supreme Court before we get anywhere else?
Well, I think you can do it simultaneously, but I think it has to be done together because this court, the Roberts Court, and John Roberts in particular, is deeply hostile to the Voting Rights Act. And I'm sure that they would strike down an effort to put forward or to pass, strike down a law passed and signed by a president along the lines of the John Lewis Voting Rights, Amendments or Restoration Act, because of that hostility, because they have adopted this sort of what they describe as a race neutral view of the 14th Amendment, even though the 14th Amendment, was designed to ensure equal protection of the law, which doesn't mean you get to have all white an all white legislature in Alabama
Right.
chosen by an all white legislature to dilute the votes of Black voters. That's part of why the Voting Rights Act was passed, was because we knew all the different ways that these white legislatures and these white counties would go about to try to limit the ability of Blacks to have representation. In the immediate aftermath of the Civil War, there was enormous representation by Black
Yeah.
Americans in Congress and in state houses. And so, you cannot just say it's okay in America for a state that is 1/3 Black to have no representation
Yeah.
in Congress. It's not okay, but it's okay with this court because they claim that a partisan goal where they get to systematically
Right.
move the Black voters around is A-okay, and it's
As if those
not.
things don't
And
coincide, who Black people vote for, and
yeah,
partisan.
yeah. So this loophole, we didn't even know this loophole existed. You could just call it partisan, and you could do all the racist
Yeah.
stuff you wanted. So yeah, I mean, the Congress has to reform this court in order to restore our rights, or this court will continue to destroy our rights.
I mean, I'm very much in favor of expanding the court. I mean, I think it's given, I'm sure Trump will get another justice in there. Someone will be there for another 30, 40 years. But do you think that I mean, you're on the inside, right? Lots of people. You've been discussing this in DC for people forever. There was no appetite for that under Biden. And, it was a very small majority. There's a lot to do. That was frustrating. But do you think that this has changed anything? Do you think there's there's a groundswell for reform, but even expanding? Like, where's the appetite, you think?
Well, I was pissed, I will say, about the so-called blue ribbon panel that did the initial review back in the early Biden administration, where, like, on the one hand, X, on the other hand, like, that was intended to thwart reform that was
Yeah.
absolutely necessary, absolutely necessary. But by the end of the Biden administration, Joe Biden and Kamala Harris were speaking out in favor of reforming the court because it became impossible to ignore what this court was doing. To assume that this court was acting in good faith, to assume that this court is just following the law or just, quote, conservative. They're not conservative. They're reactionary. They are trying to destroy the progress of the 21st century. So there's really been an awakening. And, even Rahm Emanuel, and I don't often praise him, I confess, has come out in favor of court reform. You have a lot of
Right.
Democrats who now recognize that they miscalculated or underestimated the threat that this court poses to our rights. And now it's basically undeniable.
So what does
Um,
reform look like to you? Like
yeah,
expansion, rules on the term limits? What kind of thing? It could be all the above. So that you can think at it.
yeah, I think for now it has to be all of the above because there's so many ways in which this court is broken. One solution is not going to fix it. And I also think that it's worth us really thinking about whether it's right in a democracy to have us wait every June, like at the Oracle at Delphi back in the old, olden days of Greece. Will the court, allow us to continue to have birthright citizenship? Will this
Right.
unelected, unaccountable court let us continue to have voting rights? Like that's no way to run a democracy. They're unaccountable. We need to we need to assail this judicial supremacy. We need to address the aggrandizement of the executive branch that they have put in place, which is reckless and dangerous. But also the fact that the court has made itself the kingmaker and has set itself up for like a legislative agenda every term. Now it's going to be assault weapons ban. Are they going to block the
Right.
states blocking these assault weapons? That's on the NRA wish list. The NRA was active in endorsing every single one of the Trump nominees to the Supreme Court. And they got what they wanted in the Bruen case to try to tie our laws to Clarence Thomas's vision of what a founder with a musket would have, would have allowed to be regulated back in the 79. Like this term, to have the Supreme Court considering whether, how drunk the founders were in that gun case. Could you prosecute someone for a gun crime, if they had pot. That was an over prosecution. That was a ridiculous overcharge. But the fact that we're deciding it based on whether Neil Gorsuch thinks that people were drinking or how much they were drinking and having weapons in 1791 is absurd. Same with our rights, women's rights. Why should our rights be
Sure.
assessed by the views of men who didn't give women, wouldn't give women the right to vote? We had to fight for that right into the 20th century. So like they don't get a say. They don't get to determine what our rights are based on some ancient view. Although by the way, not not for nothing, but Benjamin Franklin published a recipe for abortion in his newsletter. So it's not like it wasn't around or known to some of our founders. He was one of the most philandering founders around, so perhaps he had his
So
own
it was useful to him. Yep.
yeah, but the fact is, to go back to your original question, yeah, we need an all the above approach, but that all the above approach needs to include ethics reforms, it needs to include procedural reforms, but it also needs to include a reform of our mindset of ceding our power to an unaccountable court to limit our rights, and instead to envision a robust Congress that is an equal player with the executive branch and the judicial branch in this system of checks and balances that can advance our rights and isn't handcuffed by the Supreme Court handcuffing us with manacles. Is it manacles? Manacles from whatever they are from 1791 or whatever. Like this is no way to run a modern democracy. And as Senator Whitehouse pointed out, we were on a panel together at Netroots a couple weeks ago. One of the most democratic components of the entire American system is the House races, because every 2 years you get a chance to say, "Whoa, wrong track, pull back, change
Right.
course." Get a chance to
The
really have.
referendum almost.
Of course, the Supreme Court has tried to limit that through its machinations on these maps, but that's the most democratic component of our entire system is the House. And so I think we should be empowering the House to protect and advance our rights. And that has to be part of the reform is also of our mindset of
Yeah.
deferring to a court, of giving a court so much power, the Supreme Court this power. Now, that's not to say that the lower courts are bad. The lower courts, for the most part, are doing their job. They're following the law. But it's the Supreme Court that's just basically disregarding the law at will. And that's not okay. I also think personally, impeachment should be on the table. I would personally go volunteer for a number of impeachment efforts, but I also understand that the Senate is a wasteland for trying to get an impeachment given the rules for conviction over there. But I still
Right.
think people need to see the case made for
For
why.
justice to be impeached.
Yeah.
Yeah, I mean, I think you guys made it pretty well. It just was not taken up by people who were in charge of that. The subpoenas didn't happen, and it was kind of a lost opportunity. But I want to agree with you. I want to see it your way, in that people are ready for. I think people are ready for change. Hope the people with power are ready for that change, because I think that's the only thing where it's going to get us out of this.
Yeah, I agree, and we're in it together. My view is, our the people who came before us didn't give up because they lost one battle.
Right.
The civil rights movement was many years in the making. I think the tipping point will come sooner for us for these reforms. I think that we're not quite rapidly approaching it, but people get it. People understand that this court is out of control and is doing things that a court shouldn't do, that a fair court wouldn't do. And I think it's our obligation to not give up and give in, and to imagine that we can fix this, because we can. We lose if we don't fight. We lose if we don't try. And I refuse to let all the sacrifices for liberty and freedom that came before me die because I don't have the patience or imagination to stick with this fight, in the years to come. But I think it'll be faster. I think we could achieve reform much faster than it took them to capture the court.
I hope so. It took them a while, and we got to get it. We got to reverse it soon. But I will leave it there. Thank you so much. This has been great. I learned a lot, and really excited. Really happy to have you, and love to have you back sometime. Thanks for doing this, Lisa. How can people find all of your expertise online?
Oh, Jordan, it's lovely talking with you. Would love to come back anytime. I'm at the Lisa Graves, basically on all the socials. And I'm at Court Accountability. TrueNorthResearch.org is the research arm that I, guide. And you can find my book, and you can find me
Yes,
over on
we are
Brave
precedent.
and Legal AF. I do the Monday night live show with Dina Dahl, where we break down the news of the week. And I'll come back here anytime with you, Jordan, that you'll have me.
Amazing.
So gracious to invite me on the show. And thank you to your listeners and watchers.
Thank you so much for being here, and we will, I'm sure, talk soon.
Thank you. Thanks, Jordan. Thanks, everyone.